Welcome and thank you for joining us for Conversations with Ted. I'm Ann Schildhammer. I'm a partner with Taylor English. I focus my practice on employment law, representing companies and individuals. I also provide a lot of training to companies with respect to preventative measures, and I'm a general commercial litigator as well. With me today is my fellow Taylor English partner, Mitzi Hill.
I'm glad to be here. I'm Mitzi, and I head up our data security and privacy practice. That's a part of our corporate and commercial team. We work with technology companies and their customers both on access licensing, development, licensing work, and then my job in particular is to help our customers on our clients on both the customer side and the supplier side to comply with the heap of personal data privacy and cybersecurity needs that are being legally imposed upon them, either through new statutes or through customer contracts.
Yes, thank you, Mitzi. I understand as an employment lawyer and employment litigator, and also as an advisor, that we have the California Privacy Act that is going to take place or come into effect in 2023, January 1. That is going to now apply to employers, placing minimization requirements on what kind of personal data that an employer can collect, as well as I think data retention. So that is why we're here, and I know it's a big shift, and I'm gonna love to get your input on that.
Well, you're right that there are some new employer obligations coming into effect on the 1st of January. They will apply to covered companies that have employees or independent contractors in California. So that's an important thing to know, is this isn't just your W-2s. This is also going to be applied to independent contractors, or really anybody who is providing you services in an employee-like fashion. These sound like really new obligations if you have not done any personal privacy compliance work in your company yet. And many American companies have not, especially small and medium-sized businesses. But they are not actually super new concepts. The new part about them, the novel part about them, is that they are for the first time in the US being extended expressly inside the employment relationship. We have, going back a few years now, personal data privacy statutes, first in California and coming into effect in other states over the next year and a half, that apply to data in a consumer setting. So things that you collect about customers, anything that is personally identifying of them or their household or their device would be covered by these personal data privacy laws. Any company that has been doing business in Europe for a long time is familiar with not only these same kind of personal privacy laws, because they have existed there longer than they have existed here, but they are also familiar with the fact that in Europe, it has long been the practice that those laws apply equally to employees and to a consumer-like population. It is shifting for us into the employment bedrock. We will see whether other states pick up the mantle from California. California tends to be the leader, and sometimes they lead other states into actions, and sometimes they just, set a standard, and that becomes the de facto standard even without other states having to copy it.
Mitzi, I represent several companies that are not only located in California, they're not strictly located in California, and some of them are not headquartered. How do we determine whether it's a covered employer with respect to that? Is it based on where they're located?
That's a great question. It is not based on where they're located. They can be located anywhere in the United States, and in fact, anywhere in the world. And California has said this law applies if they meet a certain size threshold and if they have covered employees, employees in California. The size thresholds, there are 3 or 4 different ways you can calculate it, but the most common one, and the one that applies most broadly to general companies of any kind, any vertical, is a revenue threshold. And that is a $25 million annual revenues threshold, not just revenue attributable to California, but all revenue. So if your company has $25 million of revenue, regardless of where you earn it, and you have employees or customers in California, you may be subject to this law. One really important exception to that is nonprofits, no matter how big they are and how big that bottom line is, they are not subject to this. So if you are here representing a nonprofit, you can take the next few minutes off.
What can employers do? What can I advise my clients to do to get prepared for this act to go into effect on January 1?
I think a lot of companies already have a leg up because they are doing some privacy compliance in the consumer space. Anybody who's already doing that is going to have a much smaller amount of lifting to do. And the reason we have such a short window is that the California agencies that are going to be enforcing these new laws, these kind of upgrades to the privacy laws, we have been waiting all year for regulations from them about how these new laws will be implemented. Those did not come out until about a month ago. If your company already does privacy compliance, particularly California privacy compliance, you have very little work left to do. You will, and I'll get to that because it's a pretty short list. If you have never done any privacy compliance work before, I think it's worthwhile talking to your privacy lawyer, your data privacy lawyer, your in-house lawyer, whoever heads up that compliance function for you. Because what you're going to need to think about is, am I a covered company? So that'll be item 1. Do we have employees in California? That'll be item 2. And then you'll need to assess what information do I collect from those employees? What gets done with it internally? Who do I share it with externally? Those are going to be kind of your 3 big questions. Once you have answers to that, you can then start drafting a notice that will go to the employees that tells them, these are our privacy practices. We collect your social security number, we collect your medical data, we collect your bank account data so that we can administer payroll, pay your taxes, give you your benefits, whatever it is. You also will need to assess whether any of the data that you are collecting is either shared or sold within the meaning of the California statute. I don't expect that is going to apply a lot in the employment context. It's a really big deal for California business dealings in the consumer context. Most employers are not selling employee data for profit. But if you are exchanging data with an outside entity for any kind of value, or if you are allowing third parties to advertise their services to your employees, or if you are allowing third parties to crunch data about your employees in return for a discount on their services, for example, you may need to look at whether you are selling or sharing under the law. Those are not prohibited practices, but they do mean that you have to give a specific form of notice to the employees, and you have to give them the right to opt out of that.
Understood. That's very helpful. Is, typically when a new law is enacted, there is some sort of a window where companies can be protected. Is there a safe harbor window with respect to this Privacy Act?
Under the original iteration of the California Privacy Act, companies had something like a 30-day grace period if they got a complaint to come into compliance. That has been abolished by the upgrades to the privacy law that will extend this to employers. So, and we have seen that over the past 2.5, 3 years, as these laws take root in California and the regulators get more comfortable with them and the plaintiffs' bar is starting to get more comfortable with them, there is a little less wiggle room for the argument of, I didn't know, nobody told me, we didn't understand. So I think people should be prepared to hit the ground running. If you can't get everything in place by January 1st, I think having a plan to get there and a story to tell about why you are not able to get there is important. And the fact that the regulators have not confirmed until recently that this will apply, I would hope is a good reason why it might take some people longer than January 1st to have every box ticked.
Well, I think that is a lot of great information, and I think it will certainly be helpful. It's certainly helpful to me as I advise my employer clients going forward. So thanks very much for that information. I really appreciate it. Thanks everyone for watching this episode of Conversations with Ted, focusing on the California Privacy Rights Act and how it would impact employers. If you have any questions or need legal advice, you can find Mitzi and my contact information on our website, taylorenglish.com. Thank you.
Thanks, everybody.